penned a letter to Governor Gretchen Whitmer in support of clemency for Michael Thompson, who's a prisoner in the Michigan system. Can you explain how that originated, where that letter came from, and also what are the results of that letter, if any, that you've seen?
Right. Well, first of all, credit to the Cannabis Caucus. This was a case I had heard a little bit about, but I honestly didn't know all the details. And after we had our last meeting, I asked Lisa Jeminek, could you get me all the details on this inmate, including his PSIR, which is a report that's done by the probation department when they're trying to assess. It gives you details about the crime that they were convicted of, their background, information like that, and just as much information, even his disciplinary history and while he's been in MDOC and all that information. You guys had asked me to take a look at it. I did. I was shocked. Honestly, I was horrified. And, sometimes you hear something about a particular person who's incarcerated, but then once you look further, you're like, maybe this person deserves to do a little time. But I was shocked and horrified when I looked at the sentence that this particular individual, that Michael Thompson, had received. I have now practiced criminal law, set myself up for an old age joke, 26 years, 27 years now. I've never seen anything like it. I've never seen such an extreme sentence. I've never seen anybody, 3 pounds of marijuana, combined though with a felony firearm offense and also a felon in possession of firearms, which is basically anybody who has a felony conviction. You're no longer permitted to possess firearms. But then in addition to that, you can always add, if it's a crime and in the midst of whatever that crime is, you have a firearm, you can get charged with felon in possession, which is kind of ridiculous. It's sort of 2 bites at the apple, because it's saying you get charged with having the weapons, and then for having the weapons, you get charged with another crime. So, and which is done a lot. But anyway, this sentence that Mr. Thompson received, Lisa, what was the sentence again? It was crazy. It was like 40 to 60 plus 2, I think. Yeah, 40 to 60 plus 2 on the felony firearm. That's a sentence that is commensurate with particularly heinous second-degree murder cases, someone who has a criminal sexual conduct that maybe they have their habitual fourth, maybe during the course of that criminal sexual conduct case, there was torture and an attempted murder. And I mean, I've never seen anything like that before. And then in addition to that, we looked at his disciplinary history. He had 2 very, very, very minor offenses. Like one, he wasn't in line at time, I think, and I forget what the other one was. Very, very insignificant disciplinary actions over the course of all the time that he spent in prison. And I was horrified. Now remember, I don't get to make the decision. If somebody has had a legal sentence imposed, and that was a legal sentence, I thought it was a terrible abuse of discretion, but technically it wasn't illegal. I don't have the authority to pardon a person. I can't commute a sentence. Only the governor has the ability to do that. But I certainly sent her a strongly worded letter, indicated that I thought it was her obligation under the circumstances to not just seriously consider this case, but hopefully to actually commute Mr. Thompson's sentence, meaning that he would be sentenced, I had hoped, to time served and released. And so that was my request to the governor. I know as a result, they pushed up his hearing before the parole board. And Lisa, I wonder if you could explain a little bit about the process for somebody when there's a request for either commutation of a sentence or a pardon. A pardon is where you just set aside the conviction altogether. So I wasn't requesting, it seemed as though he was guilty. He was fairly convicted. I wasn't saying set aside his convictions. I was just saying release him. And that means commuting the sentence to whatever time he'd already done. So Lisa, if you could talk about the process from here on out.
Yes. So per statute, what happens is Mr. Thompson his attorneys filed on his behalf a commutation application. I believe it was filed on January 25th. And per statute, the parole board has 270 days in which to take a vote on the application, whether it has merit or doesn't have merit. Which would have been October 25th of this year. On August 20th, they did an interview with Mr. Thompson, a parole board interview, which sometimes people refer to as a hearing. And his attorney was able to be present and advocate for him. And they will discuss and vote on his case on their September 11th meeting, which is obviously a very expedited process, given that they didn't even have to get to this point until October 25th. From that point, if they vote that the application has merit, they will have 90 days to conduct a public hearing. And at the public hearing, our office has a representative, someone from my division, who represents the people and who will ask questions of Mr. Thompson and then will read the AG's letter that she wrote to the governor into the record so that it's saved there and it's part of the consideration. And from that point, if the board believes that it should go on, they will vote again. If it should go on to the governor's office following the public hearing, that will occur. And then it will be up to the governor whether she grants a commutation.
Now, regarding that 90-day period, is that a mandatory 90-day waiting period before they have the meeting, or is that a meeting that could take place in any from 1 to 90 days within that period?
Well, there is a notice period. So there's a notice period to the prosecutor and from the county of conviction and to any victims. And so I think it would be at least 30 days. I think there's some confusion about the statute, but typically the notice period is 30 days, but it must occur within the 90.
The Bureau of Prisons oftentimes doesn't make those hearings public. Is there a request that can be made from the Attorney General's office to make that a public hearing so that more people who are interested can participate or at least view?
Those are all public hearings. So, and it's available, they're being conducted now via Zoom, and the schedule is on the Department of Corrections website. It can be found there for everyone, not just Mr. Thompson, but for everyone, and any member of the public may attend any public hearing.
You previously provided our Cannabis Caucus with a list of 15 individuals who had cases outstanding in the court system, yet we've determined, as we mentioned earlier, that there were more people that have been caught up in the system than that original list would include. Is it possible for us to receive an expanded list of those particular people who may be incarcerated, not necessarily directly for cannabis, but as a result of a cannabis crime investigation?
So let me parse that out a little bit, because that's a little bit different than the request that Mike made to our office. So what the MDOC can do is pull anyone who is serving a sentence in conjunction with a marijuana charge. So for instance, you brought up Mr. Gammo. I don't know if that's how you pronounce his name. And he has marijuana charges, and he has operating a drug house charge. So that we could pick up. I think also in the example was a marijuana charge plus a tax evasion charge. That we could pick up. For Mr. Thompson, the reason he didn't end up on the list, because he had it was a felon in possession charge that he was sentenced on. And so that's why he didn't automatically get picked up on the list, because it wasn't his primary charge. So the 15 that you have were serving solely or primarily on an A prefix, a first charge of marijuana possession. So they are working, the Department of Corrections, as I wrote to Mr. McCurdy today, it's kind of a resource intensive process, but they are collecting everyone who is serving on a cannabis charge, whether it was an A or a B prefix, meaning the primary or the secondary charge, plus something else. So if it registers that they had a marijuana conviction that resulted in this incarceration with, I think you also referred to it as an ancillary charge, we will be able to pick those up. It's just going to take a few weeks to get that accomplished.
And that's fantastic. We appreciate all the work that you can put forth. And of course, the citizens of the state of Michigan would benefit from having that information, and perhaps for more potential commutations, as we're seeing with Mr. Thompson.
And again, I cannot reveal private conversations that I've had with the governor or her staff, but I think she would be fine with me saying that I think she is aware of this matter and that her office is taking this very seriously.
Well, we thank you for your role in making her aware and for communicating to her the seriousness of this issue.